Ngoba is the head of private trust in ARM Trustees Limited. She is a qualified barrister and solicitor in Nigeria and holds a master's in maritime law from the University of Nottingham. Prior to joining ARM Trustees Limited, Ngoba led and was part of the team responsible for commercial and private trust services at ALM Trustees. She's also worked in the legal department of First Bank and Access Bank, and she's been involved in structuring high-profile transactions across various industries. Ngoba is a member of the Nigerian Bar Association, the Chartered Institute of Arbitrators UK, and the Society of Trust and Estate Practitioner, STEP. In her capacity as the head of private trust in ARM Trustees, Ngoba provides an oversight role in the administration of private trust, succession, and estate planning services. Ngoba's paper is titled Estate Planning is Stitch in Time, and I'm sure it is going to really begin our foray on our sojourn into the world of estate planning. Over to you, Ngoba.
Thank you, Yemi. Good afternoon, ladies and gentlemen. Thank you for sparing some time out of your busy schedule to join us in this webinar. We hope the information we'll be sharing with you will be very useful for your purpose. I'm going to be speaking on estate planning or stitch in time. And whereas the subject of estate planning in itself is very broad, I'm going to try to see how much we can unpack on that subject in the short time I have on this call. So, typically, every individual or human being aspires to be healthy, to be financially comfortable, to be secure, and very successful in all their endeavors. This is something that we all strive to achieve at every point in time in our lives. From the moment we graduate from an institution of higher learning, we're thinking of how we could get into a blue chip company and start earning very good salaries and allowances. And then while we're in our late teens or early 20s in our careers, we're thinking of getting a fancy car. As we start to advance in age, we start thinking of also investing in financial assets like your equities, your mutual funds, your bonds. And then as we progress through the career ladder, the corporate ladder, probably in our 30s or our late 20s, we start thinking of settling down, raising a family. And then we want to own the property we live in because we don't want to pay rent anymore. And we achieve that. And as we continue to progress through our career and in our business endeavors, in our 30s, in our 40s and 50s, we decide to diversify our investments. So in addition to the property we've already owned where we're living, we want to invest in real estate and purchase property so we can earn rental income in the future. And we become more sophisticated, and then we diversify by trying to invest in foreign denominated investments abroad. And then we also start trying to acquire property in various jurisdictions. And this is all brilliant. But ponder on this for a second. If anything were to happen to you today, what will happen to those assets? Think about it carefully. So I'm going to be asking some questions, and this is our estate planning gauge, actually. We use it to determine how far we've gone in our estate planning journey, whether we are very ready for any eventualities or not, and take remedial action towards perfecting our estate plans. So I crave your indulgence. If you could just grab a piece of paper and a pen, we're going to have an interactive session, even though your mics are on mute. We're going to give 30 seconds to anyone who may not have a pen and paper nearby so that they can also be part of this exercise. So I crave the indulgence of the other attendees for these other members of the webinar to get their pen and paper for this exercise. Thank you. Okay, so I think we've done 30 seconds. Thank you for your patience. So the first question will be, As a founder of a successful business who is approaching retirement, do you have any structure in place to preserve your legacy? If anything happened to you, would your loved ones be able to access your bank accounts with little or no stress? I'm sure some of these questions may be uncomfortable, but it's something we have to do. It's very important and crucial. The subject of estate planning is never a comfortable subject or comfortable topic, but it's something that we have to do, almost like a necessary evil. Have you separated from your legally married spouse, but not divorced? Do you have a new partner you already have children with? Have you made any arrangements to ensure that your new partner and children are taken care of and have access to your assets if anything happens to you? So your answer will be either a yes or a no. What will happen to the education of your children if you lost your job or suffered business losses? Have you made arrangements for your immediate family so that your extended family members do not try to take possession of the house you lived in with your family and or other assets you own if the inevitable happens? If you have a family emergency and you need to travel abroad, are you able to travel with ease, devoid of any travel restrictions? Will your family members or loved ones have access to your dividends from the equities you invested in, or will your dividends fall into the pool of unclaimed dividends and possibly be part of the unclaimed funds, trust funds of the trust established by virtue of the Finance Act 2020? If you lost your means of livelihood, do you have a fallback source of sustenance? If you were to become permanently or temporarily incapacitated by virtue of illness or accident, will your affairs be properly managed by your family? Do you have children with special needs? How will they be taken care of if anything happens to you? Do you have any arrangements in place for those children to be taken care of? Uncomfortable questions, but I'm sure that by now we know where we are. And the whole idea of this is if you answered mostly yes, but one no, what that suggests is that you have an estate plan in place, but probably need to revisit it and to see whether it can be improved on. If you did answer no to any of the questions here, at least two no's, or two no's specifically, what that means is that you have some form of arrangements, but you need to deepen it. And then if you answered more than three no's, it definitely means that you're either in urgent need of an estate plan, you don't have one at all, or your existing estate plan has to be overhauled. Ladies and gentlemen, this is what we call estate planning, and we'll be seeing the details of that in my next slide. We'll be seeing details of that in my next slide. And so, estate planning, what is estate planning? It really is the process of management and preparing for the transfer of one's assets during one's lifetime, while minimizing bureaucratic inefficiencies. It does not connote the acquisition of real estate, as some people misconstrue. And assets here, of course, will include cash, equities, fixed income investments, real estate, your jewelry, fancy cars, luxury goods, awards, and insurance policies. Now, I hear someone on the call probably saying, okay, I think I really need an estate plan, but how do I go about it? And then my next slide shows the various estate planning tools that we can use to plan our estates. I'm not going to go into details of each and every one of them, but I'm going to actually shed a bit of light on each of these estate planning tools for your benefit. And so we have the will, which is a legal document that enables the writer, known in legal parlance as the testator, transfers his assets to his beneficiaries or articulates in writing how he wishes his assets to be distributed at the end of his lifetime. This is very, very a viable tool for people who want to be very specific about even how they want to be interred. So if you know you're from a polygamous family or you have an extended family who is very into tradition and you want to be buried in a certain place, maybe you want to be buried outside your state of origin, you need to indicate that in your will so that you reduce problems for your immediate family after you're gone. And then we have what we call the holding companies. Holding companies are basically special purpose vehicles. They're companies that are just used to hold one's interest in real estate or shares. We also have what we call a deed of gift. It's also another legal document where an individual transfers his interest in real estate property to another individual for no consideration. So it's free. It doesn't have any price attached to it. We have what we call life insurance. Of course, insurance is something that is popular with a lot of people. But in this case, this is life insurance, and it's basically a contract between the insurance policy holder and the insurance company for the insurance company to make a payment, a specified amount, to a designated beneficiary upon the occurrence of an event. Interestingly, life insurance can also be used as an investment vehicle, particularly in the international markets. We also have what we call a foundation. And a foundation is a very viable estate planning tool if one is into charity. It is a legal entity that enables its founder to execute his charitable objectives. It's a good tool for preserving the family wealth. And we have what we call the incapacity solutions. Basically, this could be a financial or medical power of attorney, where the donor, which is the person that is giving the instructions, instructs another individual, which is the donee, to execute certain actions or carry out certain decisions when he's incapacitated. So this will apply where someone is mentally incapacitated or is in a coma or just not able to function as he is supposed to. We call it the in-between situation. And we have what we call the trust. A trust is a very flexible arrangement. It's basically an arrangement where a party, usually referred to as the settlor, transfers his or her, or in case of a corporate entity, transfers his assets to another party, in this time called a trustee, to hold for the benefit of named beneficiaries. A trust has several advantages. It affords you to have asset protection, confidentiality, tax efficiency, and of course, enables you preserve the family wealth. So if you're someone who is big on your next generation, your unborn grandchildren or great-grandchildren, you want them to benefit from your assets or your estate, a trust is a useful tool for that purpose. And now, at ARM Trustees, what we do with you is we look at your situation. We provide bespoke solutions to individuals. So what that means is that we customize solutions for each individual. We don't use a one-size-fits-all kind of situation. So we look at your situation, we look at your circumstances, your pain points, and what objectives you're trying to realize. And then we recommend a solution for you. It could be just one solution you need. It could be a hybrid solution. It could be 3 solutions, but we recommend what will suit your particular circumstances and will create little or no problems for your loved ones in your absence. And so in my next slide, you'd see that there are a few kinds of trust you could set up if you're interested in setting up a trust based on the information you share and what we're able to advise you with. We have what we call a living trust. And a living trust is one where the trustee has discretion to decide the share of trust capital and income, which each beneficiary will receive. As a result, it can provide more flexibility and the trustee can respond to future circumstances as and when they arise. So basically, a lot of discretion is given to the trustee. Of course, the settlor will have communicated what his objective is, the tenor of the trust, and what he's seeking to, who the beneficiaries are, what he's seeking to realize in his trust deed, this document which constitutes the trust. And so the trustee will be guided by that document in carrying out or administering the trust. And then you have a settlor-directed trust, which is one where the trustee has partial discretion in managing the trust and its assets. And it allows the settlor of the trust to retain certain powers in respect of the trust. So here, the trustee doesn't have as much discretion as we would have under the living trust. So in this kind of scenario, we will have to carry you along and we'll seek your consent before we carry out any instructions. So for example, if you were to move your financial assets to the trust and you have a fixed income investment, upon maturity, we'll always come back to you and ask you for what you want to do with that investment, whether you want a total payout, or you want us to reinvest just the principal, or you want us to pay just the income, the interest on the investment. And we have what we call the education trust, which strictly speaking, as the name suggests, just allows the settlor to set aside funds to cater for the education and welfare of the beneficiaries, regardless of permanent disability or death. So this will be useful for parents, for guardians, for even friends, a group of friends who want to take care of maybe a deceased friend or a deceased colleague's children and don't want to get into the administration of such. You can always appoint a trustee for this purpose, arrange with the trustee, execute the trust deed, and then the trustee will carry out your instructions, make payments directly to the school, and just ensure that the beneficiaries, the children, are well taken care of, and their welfare is also given attention to. And in my next slide, we have a life story. And that's the story of Chief Ganifawa GCON, SAN. We call him our estate planning model. He passed on the 5th of September 2009 at the age of 71. He left behind 2 wives, more than 14 children, and other numerous beneficiaries. He created a testamentary trust by his will and stated that the companies that formed the golden geese of his estate should be managed by his trustee. He also directed that his surviving family members, beggars, and the poor should be taken care of from the proceeds of those companies. Honestly, Chief Ganifawa is a fantastic estate planning model. And there's several lessons we can learn from the story of Chief Ganifawa, particularly from the context of estate planning. One is peace of mind. Chief Ganifawa had peace of mind while he was alive, knowing that his family will be taken care of after he's gone. He had made all the arrangements in place. 2, avoidance of conflicts. So we have not received or heard about any form of bickering in the public space regarding his children. Perhaps maybe there's something that we're not aware of, but publicly we haven't heard of anything, unlike some families where the patriarch dies without any form of estate plan, and the children, the family members are bickering, they're going to court and doing that. Chief Ganifawa avoided that ugly situation. A third lesson we learned from Chief Ganifawa is the subordination of the state law. And what we mean here is his wishes took priority over the laws of the land. In this case, the laws of Lagos State, the administration of estates law of Lagos State, which would have applied if he died without an estate plan. So he decided his wishes because once you have a will, your will takes priority over any other thing, even in the course of the probate process. And last but not the least, another lesson, asset inventory. So by having an estate plan, it gives one the opportunity and gave Chief Ganifawa the opportunity to know what he actually owns and basically make more arrangements if he needed to buy additional assets or reorganize his estate. He took control of what he owned. It gave him a clearer picture of what he owned, and then he did the needful. So I hope some of this information that we've shared so far, you found it insightful and useful. I thank you for listening, and I'll let Henry speak on estate planning from an international perspective. Thank you.